All right, it's 22 minutes before 7 here on this Friday morning. A very, very good morning to you. All right, the story, of course, that's been trending since yesterday. Oscar Pistorius will sit for trial again after the Supreme Court of Appeal in Bloemfontein overturned the culpable homicide verdict by the North Gauteng High Court to murder. Yesterday, Justice Eric Leach said Pistorius should have been found guilty of murdering his girlfriend, Reeva Steenkamp. This turn of events is expected to bring a new outcome as the case is referred back to the High Court. Michael Motsoeneng, who is from the Motsoeneng attorneys, joins us here in studio. It's so good to have you. Welcome to Morning Live.
Good to be here.
Good. Let me just get your name right. It's Michael Motsoeneng Bill, correct?
That's right.
All right, thanks so much. Now, the argument has been on whether Judge Masipa did or did not correct the rule of dolus eventualis. Did the judge's argument manage to establish dolus eventualis now?
I think that was the difficulty from the beginning, and I think the decision from the Supreme Court of Appeal is very much welcomed, because if you look at the judgments that have come out from the High Courts over the last 2 years, they've been somewhat confusing on what dolus eventualis is. But to many lawyers, the case of Oscar Pistorius was one that established dolus eventualis because the circumstances of the matter were such that you can't reach a different conclusion. And the fact that if somebody fires 4 shots into a closed cubicle, when that person, by their own version, says they knew that somebody was inside that cubicle, it's very difficult to escape the conclusion that dolus eventualis was applicable to the circumstances.
Yeah. So, did you find that the ruling yesterday was a lot more applicable than what was originally handed down?
Oh yes, but and it's not just applicable, but it's actually correcting the errors that had happened in the High Court, because it was certainly an error. Dolus eventualis, as we had always been maintaining, was not correctly applied, and the High Court judgment took me in particular by surprise. And this is a correction of that, because then we're going to what we all understand as being dolus eventualis. Dolus eventualis does not concern itself with the identity of the individual concerned. It is not about whether you foresaw that you'd kill Reeva. It's whether you foresaw that you'd kill a person. And
someone.
in this case, Oscar Pistorius foresaw that he would kill somebody. In fact, the different accounts that he gave indicate that he did foresee that he'd kill somebody, albeit there are different versions. And as the court correctly said, it's very difficult to say which of the 3 versions to accept.
Yeah, I think the example that Justice Leach gave yesterday about putting a bomb in a square and the bomb going off, you're going to kill someone.
That's absolutely what dolus eventualis means. It's not your intention to kill. In other words, he didn't get off his bed saying, today I want to kill somebody. Yeah. But the circumstances when he hears that sound and the steps that he takes, he foresees that he will shoot somebody, and he will shoot that person fatally. And the example of a bomb is one good example, but there are many such examples. And even this case, I believe that this very case will be used as an example in cases to come, because if you do fire 4 shots, and at the height, as Captain Mangena has indicated, you must foresee that you'll shoot somebody fatally.
In the handing down as well yesterday, Justice Leach also found errors where some crucial evidence had been ignored, and Captain Mangena was brought into this conversation. I mean, let's talk about this evidence that was ignored.
Captain Mangena was always a star witness. I think he was, for the police, most credible and knowledgeable. That's what we call an expert witness. And what he indicated is certainly the position of the shooting and the trajectory, and he indicated the shots that were fired. And that goes to the circumstances of what was happening in the cubicle, because nobody can really know what was happening in the cubicle. How you get to arrive at conclusion of what was happening in the cubicle is when there's a reconstruction of the events. And Captain Mangena, that's where he came in, and the circumstances that we're giving indicate that Reeva was shot in the front, and then she fell on the basin of the toilet.
Yeah. Now, I mean, from the beginning, and I know you mentioned it as you opened up here this morning, that when this was first handed down, you were automatically shocked. It shouldn't have been that way.
It was indeed.
You predicted the outcome, that it would be changed to murder. What was your conviction? Why were you convinced of it?
When we're talking about dolus eventualis, even if you're not a trained lawyer, and I say, what would you, if you know that there's a person in a closed cubicle, and you fire let's actually take you a step back. You'll remember when arguments were made at the appeal court. One of the judges was saying, but there is no, when talking to Garinel, they were saying, there was no space in that cubicle for somebody to escape those bullets. It was so small. So when you then keep that in mind, and then you go back to the trial court and you say, if you fire the 4 shots at the region in which they were fired, is there a possibility that anybody could escape? Or can you leave doubt in your mind that I'm going to fire these shots and maybe I'll just scare them away? This was certainly not such a case where you're scaring the person away. It's not 1 shot, and that's important. It's 4 shots, and somebody who fires 4 shots I say this reluctantly, but is in a battle.
Yeah. And also with the type of bullets he was using.
And the type of the bullets that he was using. And that was also a factor. But if you then take that and you understand and we ask you a question, even as a layperson, do you think that the person inside of a cubicle would have escaped death in those circumstances? The answer would, for most of us, in fact, if not all of us, would be, no, they wouldn't escape death. And that's exactly where foreseeability then comes in, and which is an element of dolus eventualis. If we all conclude that the person would not have escaped death, then it must follow that Oscar Pistorius foresaw at firing those shots that he would kill somebody.
There's been a lot of criticism, and the public have voiced their disappointment on the initial ruling, hence towards Judge Masipa. Yeah. Is it valid? I mean, is it fair?
You know, the thing about our courts is that even the Supreme Court of Appeal itself is not immune from criticism. If you read some judgments in the Constitutional Court where it's a bigger bench, they critique the Supreme Court where it errs. So all courts err. No one court is immune from that. In fact, even the Supreme Court of Appeal itself, sometimes a decision that was handed years ago is changed, and decisions change because there's a different a body that is sitting, and they apply their mind to the facts. So what Judge Masipa made is nothing out of the ordinary. She erred like any judge errs. It is for that reason that we have an appeal. In fact, we hear in the news of appeals happening day in and day out, because when you as a litigant feel aggrieved by the decision of a judge, you have recourse to a bigger sitting. It's not one judge, it is 5 judges, and you have then the benefit of 5 minds able to decide on whether your point or your allegation that the judge has erred is correct or not. Yeah. So I don't think that this is a personal indictment on Judge Masipa. It is certainly a correction, and it is a victory for justice.
Is it a victory for justice? Because, I mean, we were on a global scale with this kind of ruling, and I imagine, just as you were watching, there were many other judges and advocates and lawyers around the world watching this and thinking, you've got to be kidding me, this is ridiculous. How can the judge rule this way? So having it overturned, I mean, who's won here?
You see, for me, when I say it's a victory for justice, I'm not looking at it Oscar versus Reeva. I'm looking at it, what did we understand as dolus eventualis? And what I understood as dolus eventualis for the last many years, what happened in the High Court was inconsistent with my understanding of dolus eventualis. Okay. Now, what the Supreme Court has done is that it's gone back and it's affirmed my initial understanding of dolus eventualis. So it's a victory for justice in the sense that when such matter presents itself in the future at court, the courts will be able to rely on this Supreme Court ruling and say, actually, the Supreme Court of Appeal has found in the matter of Oscar Pistorius 2015 that dolus eventualis is this and it's nothing more. And they've corrected any debate, because it is an old system. Dolus eventualis is not an invention of the last 20 or 30 years. It's something that emanates from our common law, which we've imported into the South African legal system. So over the years, it has been criticized, and it's developing and it's growing. So when we're talking about a decision from the Supreme Court of Appeal, it's bringing clarity and growing our law. And from that point of view, it is indeed a victory for justice.
All right. I'm going to take a break here on the program. I'm going to ask you to stay if that's okay with you. We've also, after this break, we'll talk about where to from here for Oscar. Has he got any legal rights? I know we've spoken about the Constitutional Court, but we will get the expert opinion on that. And we have the exclusive interview with Reeva Steenkamp, the mother of the late Reeva. Stay tuned.